18th Annual Supreme Court Review. My name is Lauren Jones, and I'm the Civil Rights National Counsel at the Anti-Defamation League. And I am very pleased to be coming to you live again from the National Constitution Center in Philadelphia for the 5th year. I want to thank the National Constitution Center for being such wonderful hosts, particularly their CEO, Jeffrey Rosen, and Tanaya Neal, who once again has made today possible. For those of you who are here at the National Constitution Center, if you're interested in becoming members, you can do so out in the lobby right after the program. I have the distinct pleasure of being up on stage with our distinguished panelists today, but of course there are so many other people who have been working behind the scenes and who have made today possible. And first, of course, is our legal team at ADL and the lawyers that we have worked with around the country on so many of the briefs that you will be hearing about today. Some of them are actually here with us at the National Constitution Center. Deborah Lauder, our Senior Vice President of Policy and Programs. Steve Freeman, our Deputy Director of Policy and Programs and our Director of Legal Affairs. Michael Lieberman, our Washington Counsel. And Aaron Sussman, our Associate National Civil Rights Counsel. And of course, there are others around the country. I also want to thank Nancy Barambert, who's our Regional Director here in Philadelphia, and the team that has been working here in Philadelphia, as well as Daniel Kelly, who has been working behind the scenes to make sure that all of this goes off seamlessly and without a hitch. And of course, to our videographers and to our web team at ADL, who are making sure that all of you around the country can see us and hear us today. And to the staff and our colleagues around the country who have put together programs. We have 26 regional offices around the country, and there are viewings all over the country. So for all of you who are watching on the live stream, welcome. We're so glad to have you with us today. Before we get started, there is just a little bit of housekeeping, and that is for those of you who are interested in getting continuing legal education credit, CLE credit. There will be 2 codes that run across the bottom of your screen at different times throughout the program. Please make a note of those codes. If you are watching on your own computer and have registered, you should have already gotten an email with an evaluation form that you can submit with those codes. And if you're watching at an ADL event, you should have an evaluation form in front of you, and please fill that out. There will be a little bit of time for questions at the end of the program. For those of you who are here in the audience, we will have index cards where you can write your questions. And for those of you who are watching around the country, you can send us questions on Twitter using the hashtag SCOTUSReview. So we hope that you will join the conversation with us on Twitter. For those of you who may not be familiar with the Anti-Defamation League, who are tuning in for perhaps the first time, ADL was founded in 1913 with a dual mission: to stop the defamation of the Jewish people and to secure justice and fair treatment to all. That mission has carried us through for more than a century, and it guides the work that we do each and every day on many of the issues that you will be hearing about today, including separation of church and state, immigration and refugee rights, LGBT rights, voting rights, criminal justice reform, and so many more. And so you'll hear that we actually filed briefs, amicus briefs, in many of the cases that you will be hearing about today, including around the country in what has become known as the challenge to the Muslim ban or the travel ban, or sometimes referred to as the refugee ban. So we have what I think will be an exceptionally interesting program today, and I want to get right to it because we will be talking about the newest justice on the US Supreme Court and what Neil Gorsuch means for the future of the court. We'll be talking about the most important cases of this term. We'll be talking about challenges to the president's executive orders, including the refugee ban, and we'll be talking about what we can expect from the court coming up next year. So I am joined by an incredibly esteemed panel, and we are so pleased to have them with us today. So to my left immediately is Erwin Chemerinsky. As of July 1st, he is the Dean of UC Berkeley School of Law. I believe that this is his first public program since becoming Dean. So we are so thrilled that you are here with us today, and we congratulate you on your new position.
Thank you. Thank you.
Before assuming his post at the University of California at Berkeley, Erwin was the founding dean and distinguished professor of law at the University of California Irvine School of Law. He is one of the leading scholars on constitutional law, federal practice, civil rights, and civil liberties, as well as appellate litigation. Erwin is the author of 10 books and more than 200 articles in top law reviews. Earlier this year, National Jurist magazine named him the most influential person in legal education in the United States. Then in the center is Frederick Lawrence. He is the secretary and CEO of the Phi Beta Kappa Society, America's first and most prestigious honor society. He's also a visiting professor at the Georgetown Law Center and the McCourt School of Public Policy at Georgetown University. He has previously served as the president of Brandeis University, dean of the George Washington University Law School, and visiting professor and senior research scholar at Yale Law School. An accomplished scholar, teacher, and attorney, Fred is one of the nation's leading experts on civil rights, free expression, and bias crimes. And then at the end of the panel, last but certainly far from least, is Dahlia Lithwick. She's a senior editor at Slate, where she writes the Supreme Court dispatches and jurisprudence columns. She also hosts the weekly podcast Amicus, which I would highly commend if people have not been listening to it. She has been a guest commentator for the New York Times editorial pages. Her work has appeared in the New Yorker, the Washington Post, Commentary, and many more. So please join me in welcoming Erwin, Chemerinsky, Fred Lawrence, and Dahlia Lithwick. So let's dive into the meat of it. So Erwin, first to you for an overview of the term. This has been a sort of unusual term. So what are the major takeaways?
It's such an honor and pleasure to be here, and wonderful to Lauren and Fred and Dahlia again. This was the term of 8 in the United States Supreme Court. From the first Monday in October until the April argument calendar, there were only 8 justices. This affected literally every aspect of the court's work. It affected the pace with which the court granted review in cases. As recently as early January, there were less than 50 cases on the docket for this term. It affected the type of cases with which the court granted review. There's no decisions this term about the most controversial issues like abortion, affirmative action, Second Amendment gun rights, gay and lesbian rights. These are the kind of issues that predictably lead to ideologically divided 5-4 rulings. I think the court intentionally stayed away from them this term. In fact, this term, about half the cases were decided unanimously. It's not that the justices found consensus and overcame their ideological divisions. It's just that the cases on the docket this term was much less likely to produce the usual kinds, predictable divisions among the justices. Also, it's important to keep in mind, when there are 8 justices, there's the real possibility of deadlock, 4-4 ties. And the justices have some options when that happens. One is to put a case over for re-argument next term. On the last day of the term, Monday, June 26th, the court put 2 important immigration cases over for re-argument next year, reflecting that they were tied 4-4. One of the other things that the justices can do when they're deadlocked is look for a compromise. Try to find a narrow ground that a majority can agree upon. And I think in several of the cases this term, that's exactly what the justices did. They ruled very narrowly, leaving the harder questions open. One other reflection of the smaller term is of the deadlock of 4-4 and the fact that it was a term of 8 was that the justices decided fewer cases than any year in recent memory. By my count, the justices this term decided 57 cases after briefing and oral argument. If you think about it, as recently as the 1980s, the court was averaging over 160 cases a year. For much of the 20th century, the court was deciding over 200 cases a year. To go from that to this year's 57 is truly remarkable. The other overall characteristic with regard to the term is familiar. It is still the Anthony Kennedy court. Justice Kennedy voted in the majority in 97% of all the decisions, the most of any of the justices. In fact, even if you take out the unanimous cases and just focus on the ones where there was a division among the justices, Justice Kennedy was still in the majority 93% of the time, or 10 percentage points higher than the justice next, Chief Justice Roberts, who was in the majority 83% of the time. So for the lawyers who are here and watching, if you have a case before the Supreme Court, my advice to you is make your briefs a shameless attempt to pander to Justice Kennedy. If the clerk of the court will allow it, put Anthony Kennedy's picture on the front of your brief. It also, of course, explains why there's so much attention to the possible retirement of Anthony Kennedy, is we'll talk about Neil Gorsuch replacing Antonin Scalia largely restores the court's ideological balance to what it was before Justice Scalia died on February 13th, 2016. I actually think that Justice Gorsuch might be in some areas more conservative than Justice Scalia. But if Justice Kennedy leaves the court, then we will have the most conservative court there's been since the mid-1930s. And keep in mind that since 1960, 78 years old is the average age at which a Supreme Court justice left the bench. As we're here today together, there are 3 justices who are 70 or older. Ruth Bader Ginsburg turned 84 on March 15th. Anthony Kennedy will turn 81 on July 23rd. Stephen Breyer will turn 79 on August 15th. If any one of these 3 justices leaves between now and January 20th, 2021, it will dramatically change the ideological composition of the court. And I think that's the context in which we have to look at this term.
Thank you. So, Dahlia, Erwin had mentioned that he thinks that Justice Gorsuch may be even further to the right of Justice Scalia. So can you talk to us about what we've already seen from Justice Gorsuch, what that may sort of indicate about where he is on the left-right spectrum, and what we can expect from him?
I can't. First of all, I want to say thank you. This is truly one of my great pleasures of the year, and I also, precatory caution, I'm sick, and so if I cough on the front row, I'm sorry. I want to, if I cough on the second row, you're on your own. I want to just go back a little bit and give a little bit of context in light of what we talked about last year when we were looking at Merrick Garland, had been selected by Barack Obama to fill Antonin Scalia's seat. And just as a brief reminder, on February 13th, when Justice Scalia died, within an hour, Mitch McConnell was tweeting, and soon after, Ted Kennedy was tweeting, there's going to be nobody selected by this president is going to get a hearing. We're going to let the American people decide. Last March 16th, Obama tapped Merrick Garland, I think demonstrably, clearly qualified nominee. And then, as you recall, when we sat here last year, crickets. Nothing happened. There were many senators who declined to even meet with him, much less give him a hearing and a vote. And the only thing I want to say by way of context before I talk about Gorsuch is that a lot of the senators, particularly in closely fought races on the Republican side, when we talked about this last year, were still running away from the fact of obstruction. We're still saying, you know, when they were questioned about why they were not giving Merrick Garland a hearing, would tend to say, you know, squirrel and run, and that by October, November, they were openly running on the obstruction. And we were hearing, I mean, I think that it's clear that the court was struggling with 8 members, both at the end of last term, when there were a whole bunch of ambiguously resolved cases and cases that the court, in addition to the factors Erwin mentioned, it's worth saying, you know, the court declined to take some really important cases this year because they were afraid of deadlock. But I think that by October, November, we were seeing Ted Cruz, John McCain openly running on the fact that they had obstructed. And it was an interesting pivot, and I think we missed it in the media, that what had been sort of an embarrassing proposition, you know, you're not going to give this guy a hearing, that's so strange. Anthony Kennedy was seated in the last year of a president's term, turned into not only are we going to obstruct, but we will keep this seat open for 4 more years if need be, if Hillary Clinton is elected. So that was a massive shift that happened, and I think with one exception, possibly, every one of those Republican senators was reelected, having openly campaigned on keeping that seat vacant. And I say this only because when we look at the exit polls last November, of the Americans who voted with the Supreme Court as their #1 issue, why they were going to the polls, by almost a 2-to-1 margin, they broke for Donald Trump. So there was a profound, I think, enthusiasm gap in terms of how voters construed the vacancy on the court. And an awful lot of people willing to hold their nose and vote for Donald Trump because they wanted to see that seat filled. Much fewer willing to hold their nose and vote for Hillary Clinton. Okay, Neil Gorsuch has his confirmation hearing. He has a lengthy paper trail. There's no debate I think, as to what he is going to be. And I think this will become important when we talk about the religion cases toward the end of this panel. But it is clear that where he has really laid down markers in his career on the 10th Circuit is on these collisions between religious freedom on the one hand, religious dissenters who feel that they do not want to comply with various civil laws, and the collision with the civil statutory regime that protects equality. And it's clear because we know Neil Gorsuch wrote in the first iteration of the Hobby Lobby case. He wrote in the first iteration of the Little Sisters case. He's written extensively on right to die issues. So we knew precisely where he was on this question of the intersection between faith and civil liberties. And his hearing was really a remarkable, I think, exercise in watching Senate Democrats who came to the table uncertain about whether they were going to filibuster, coming out quite certain that they were going to filibuster. And there was a lot of internecine debate among Democrats on the Hill about whether this was the hill to die on or whether they should hold their powder and filibuster whoever comes to fill Justice Kennedy's seat. But at the end of the day, Senate Democrats felt that nominee Gorsuch didn't fully answer questions, and that the answers he gave were worrisome, and the filibuster, as you know, occurred, and the Senate Republicans opted for the so-called nuclear option, and Gorsuch was confirmed. I think I'll just conclude my remarks about Gorsuch by saying that he has, in the months that he was on the court, so he really only sat for the last sitting, for the April sitting, only heard a small number of cases, but has really, I think, established himself as a very, very bold jurist. There is usually a 2-3 year lag time before justices feel really comfortable, busting out lavish written opinions, staking out strong positions. Gorsuch has shown no such hesitation, both at oral argument, where he's been very, very, very verbal, but also I think in one case after another, particularly in the last few weeks, has, as Erwin said, consistently voted with Clarence Thomas, arguably to the right of Sam Alito and arguably to the right of where Scalia would have come down, but also in cases that we'll talk about later in the program, has dropped a dissent from a refusal to hear a case in one that was quite extraordinary, has dissented in other cases, and has really, really made it very clear who he is and where he is. And it's worth saying that he's 49 and may sit for 30 years. And just as to the rumors that Anthony Kennedy's retiring, it's worth flagging for people who didn't catch it that this week Nina Totenberg reported, I think fairly credibly with other sources confirming that it's quite clear that Justice Kennedy, while he didn't retire last week, everybody was clamoring, and we all got canceled from the TV shows when he didn't retire, but that there is an extremely good chance, he's saying, that he will retire in 2018 in the advance of the midterm elections.
So a lot to chew on, and a lot to think about for next year and the years after that. But Fred, I wanted to turn to you to talk about some of the cases, to start talking about some of the cases that we had this term. So we heard that we didn't have the same kind of blockbuster cases that we have had in the past, but there was, in particular, one case that was held to the end of the term that ADL was watching very closely. We had filed an amicus brief in this case, and may have some serious implications for separation of church and state going forward, and that's the Trinity Lutheran case. So can you talk to us about what that case is and what happened?
Sure. Let me start by adding my word of thanks for again being here. I think Erwin and I have now done this 17 years together, and Dahlia, this is your 3rd year with us, so you're now officially part of the team, and we're not letting you go.
Absolutely not.
So far as I can tell, the only risk that Erwin and I have experienced of the wonderful opportunity to work together for over a decade and a half in this is that neither of us can hold a job. But it's wonderful to be in the positions that we're in, and I would certainly agree that Erwin Chemerinsky is the leading figure in legal education, and as someone who still considers himself part of the legal academy, in addition to being head of the Phi Beta Kappa Society, I'm glad to call him my leader. Trinity Lutheran is either a big case or a small case, depending on what you make out of a footnote. what is likely to be a footnote that we will ponder for years to come. So if you follow the majority opinion of Chief Justice Roberts and Justices Kennedy, Alito, and Kagan, then this is a small case about playgrounds. But if you follow either Justices Thomas or Gorsuch, so that's the first time we'll hear his name in a substantive case, it won't be the last today, or on the other end of the spectrum, Justices Sotomayor and Ginsburg, then it is a big case, or at least potentially a big case. So what happened in Trinity Lutheran? You'd be hard-pressed to find a more prosaic setting for a case. It involves the Missouri Department of Natural Resources offer of playground scrap tire surface material grants. Doesn't even have a good acronym, those grants. Trinity Lutheran has a religious school, obviously, and has a licensed preschool, and sought one of these grants for their playground. They clearly would have been qualified by all the objective measures for applying for the playground. The one factor that caused them to be denied the grant by the Natural Resources Department is the fact that it's a religious institution. Missouri, as many states, has a Blaine Amendment in their constitution prohibiting the use of state funds to advance a religious institution. So the question was raised on behalf of Trinity Lutheran whether the denial of the funding for their playground, for them to have this playground grant, interfered with free exercise of religion. Now, keep in mind, the question here is not what it typically is, or often is in our cases, whether had Missouri provided the funds, that would have been an establishment of religion. The question rather is that Missouri in their constitution says, thou shalt not have funding for religious institutions. Is that a violation of free expression? For those who are having a deja vu all over again feel, this is a descendant of Locke against Davie, a case that the ADL was involved in that we talked about at this panel some years ago, Locke against Davie, a Washington State case involving a similar Blaine Amendment where the Supreme Court upheld the denial of funds in that case for use in a religious context, an individual who would have arguably used scholarship funds to study theology. So coming back to Trinity Lutheran, the argument anew that this was a violation of free exercise of religion, and the Supreme Court upholds the argument that the denial of funds to Trinity Lutheran is in fact religious discrimination. The case is designed or viewed by Chief Justice Roberts, in his opinion, as a flat-out case of religious discrimination. Were they not a religious institution, they would have gotten the grant. It's because they are a religious institution. They don't get the grant, therefore it's religious discrimination. So is this a big case or a small case? Well, footnote 3 says this is a case about playgrounds. And we leave for another day the question about broader questions of religious discrimination. Justice Sotomayor writes a stinging dissent joined by Justice Ginsburg, making the claim that of course this is a distinction based on a religious institution. That is precisely what the Establishment Clause is about, and that the authority granted to states and upheld in Locke against Davie to have particular constitutional amendments, state constitutional amendments that deal with this issue, provides for states to be able to control this. Therefore, this is a major change, a major shift that could require public funding of religious institutions. One might argue that the dissent was written to an opinion that is not quite what the opinion is, because footnote 3, and one can imagine that it came in late in the game to buy a few extra votes and to buy a little piece in the House, says this is only about playgrounds. But we all know that, as Oliver Wendell Holmes famously said, every idea is an incitement. And so we begin here talking about playgrounds. Unless we have any doubt, Justice Thomas and Justice Gorsuch write the opinion that each write separate concurrences. Justice Thomas suggesting that Locke against Davie may have it wrong. As a matter of fact, he says, just let me read very briefly, the court's endorsement in Locke of even a mild kind of discrimination against religion remains troubling. That's Justice Thomas. And Justice Gorsuch, for a brand new justice, is playing see you and raise you, and writes a concurrence in which he seems to suggest that Locke and Davie was incorrectly decided. My guess is we'll have more to talk about in the years to come about Neil Gorsuch and the separation of church and state.
Erwin, did you have a different take or wanted to add something?
I would add, Justice Sotomayor in her dissent said, this is the first time in American history that the Supreme Court has ever said that the government is required to provide aid to religious institutions. There are so many areas where the government provides aid to private secular institutions, but not to religious institutions. In all of these now, I think you're going to see lawsuits brought by the religious institutions saying the government's discriminating against us because we're a religious institution. I remember one of the first programs I did for ADL was on what was called then charitable choice. Should the federal government change its programs so that when it gives aid to secular institutions for things like preschools, drug and alcohol rehabilitation, it should give it to religious institutions as well. Previously, the religious institutions would need to set up a separate, non-religious arm to receive the aid. The concern that I have is that this decision could lead to constitutionalizing charitable choice. It would say that the government is constitutionally required to provide this assistance to religious institutions whenever it provides it to secular institutions. That's what Justice Sotomayor was so concerned about, and I think it's a worry we all need to have.
And I would just add one thing, which is, insofar as we used to talk about how who was an originalist and who wasn't, Justice Sotomayor's dissent is actually a deep, deep dive into this anti-establishment principle that states put into their own constitutions that go way farther than the federal constitution was, because the states were so anxious at the founding about the proposition of either funding religious institutions or having to choose between funding religious institutions. So this is a sort of deeply seated historic anxiety. And Justice Sotomayor goes to great lengths to write an originalist dissent, saying this absolutely flies in the face of why we have these clauses in state constitutions. And nobody even sort of responds. And so I think to the extent that, on the one hand, you can say we're all originalists now. I guess at least in this context, Sotomayor is. But it's very, very interesting to see that almost vaporized in terms of how the majority analyzes the question.
So Erwin, I wanted to turn to the second half of the First Amendment, and that is about free speech, the Mittal versus Tam case. So what was that case about, and what's happening there?
Simon Tam is the leader of a rock group out of Portland, Oregon. All of its members are Asian American, and they call themselves the Slants. Slants is a derogatory term sometimes directed at Asians. They intentionally chose that as the title for the band, saying they wanted to appropriate the term back to the Asian community. They analogized to how the word queer used to be thought of as derogatory, but then the gay and lesbian community came to embrace it and appropriate it back. They sought to register the trademark, the name of their band, but there's a provision of the law governing trademarks, the Lanham Act, that prohibits the registration of trademarks if they're disparaging, including to any person or people. And in fact, can't be registered as disparaging on many different grounds. The officer in the Patent and Trademark Office refused to allow the registration of the trademark on this basis. The Patent and Trademark Office upheld this, but the United States Court of Appeals for the Federal Circuit declared this provision of the Lanham Act to be unconstitutional. The Federal Court of Appeals said that this is a content-based restriction on speech. It violates the First Amendment. The Supreme Court unanimously upheld the decision of the Federal Circuit and declared this provision of the Lanham Act unconstitutional. What's interesting is the justices split into two groups of four with regard to their opinions. You had Justice Alito write for one group, and his opinion was joined by Chief Justice Roberts and Justice Kennedy and Justice Breyer. Justice Kennedy wrote a separate opinion joined by Justices Ginsburg, Sotomayor, and Kagan. To a large extent, the 8 justices agreed. They all saw this as viewpoint discrimination with regard to speech. If this rock group had chosen a name that was favorable to Asian Americans, it would have been allowed. But because it's disparaging, it wasn't allowed. And all of the justices said that's why it violates the First Amendment. All of the justices said that the government can't regulate speech just because it's offensive, even deeply offensive. Justice Alito, in his opinion, makes this point. He powerfully quotes Justice Oliver Wendell Holmes, who said, "We most of all need the protection of free speech for the speech that we hate." Justice Alito's opinion focused mostly on answering the arguments that the government had put forward. the government had said the trademark should really be thought of as a form of government speech. And when the government is the speaker, then what it says can't be challenged as violating the First Amendment speech clause. Justice Alito said, this isn't the government speaking. This is a rock group choosing its title. He said, if trademarks were thought of as government speech, then the government would be babbling incoherently. He said, even if we thought of this as a form of commercial speech, the government doesn't have a sufficient interest to be able to regulate it. I think Justice Kennedy wrote separately and was joined, as I say, by Justice Ginsburg, Sotomayor, and Kagan to make the point that this is viewpoint discrimination, and viewpoint discrimination is never permissible under the First Amendment. So what are the implications of this case? Well, I certainly think it has implications in the area of intellectual property law. If you think about it, all copyright and trademark law is about restricting speech. This is the first time the Supreme Court has ever found a provision, copyright or trademark law, to violate the First Amendment. There are a number of other provisions of the Lanham Act that could be seen as content-based, even viewpoint restrictions on speech. This is going to open the door to challenges to these. But the even larger significance, I think, is 8 of the justices so emphatically embracing the idea that the government can't punish speech because it's offensive. There's obviously a major debate in this country about free speech on campuses and elsewhere. And I think the court here is sending a message that public universities, governments more generally, just cannot punish speech, create liability for speech, deny benefits for speech on the ground that speech is offensive.
And it's interesting that they took this case as opposed to the Redskins case or some of the other cases that we've been hearing about of some of the offensive sports teams' names. So Dahlia, did you have anything to add about this case?
The only thing I would add, and it's just by way of a piece of gossip, is that I've been hosting my podcast for two years, I think. And Simon Tam, the lead singer of the Slants, who is a rock star and not a constitutional theorist, proves to be one of the most insightful guests in breaking down this case that I've ever had. So I just think it's really was a fascinating case just in terms of him hearing how tremendously important it was to him. Even though he knew he was carrying water, by the way, for the Redskins, but how tremendously it was important to reappropriate the name the Slants in an effort to sort of fight against anti-Asian American stereotypes. So it was just a really sort of upside down case from his perspective, but fascinating.
I was going to add something, but you got rock stars. I don't know how I can beat that. Beat that. I had the privilege, the day after the case came down, of testifying before the Senate Judiciary Committee on free speech on campus. What was interesting to me is that the case was obviously very front and center in the discussion. And across the board of people of different views, and senators certainly of different views, high consensus on this issue of the value of the protection of speech. We're going to talk a lot about places where we are polarized and different, as we should, but we shouldn't walk away too quickly from how powerful a position that is, that we still hold to that, and that United States senators sitting in front of witnesses talking about something the Supreme Court had just decided and talking to each other respectfully and civilly is still possible in this country. And I don't say that lightly. It reminds us, I don't want to get to July the 4th on you, but only a couple of days after and not that far in distance from where it all began, that's still possible is a powerful piece that comes out of this case.
That's a nice message to carry from that. I like that. So Dahlia, I want us to turn away from the First Amendment now and to talk about racial bias in the criminal justice system. There were 2 big cases. ADL filed in one of them, in the Pena-Rodriguez case. But then there was also Buck versus Davis this year, where there were some really striking, awful cases of racial bias. So what happened with those cases?
Two themes that I would pick up on from Erwin's opening. One is that it was a very strange docket, and it has been characterized by some as a kind of error-correcting docket. And so a tremendous number of cases were taken. In some ways, Pam Carlin at Stanford described it as just the outrage docket. that there were some cases where the facts were so outrageous that the court needed to step in, not to really shift doctrine in some big way, but to make a point that some things are still a bridge too far. That's one theme, and I think both these cases look like that. The other theme, and I know we talked about it this time last year, it's worth pulling at it a little, and we can pull it again later, is that one of the real trends that emerged at the end of last term and then again at the end of this term is John Roberts, the Chief Justice, and Anthony Kennedy starting to either pull to the center or watching the right wing of the court pull to the right. And I remember sitting here last year and saying, watch Clarence Thomas and Sam Alito, because they were dissenting separately. They were really sort of making a point at the end of last year. And that trend really continues with these two cases, where both Anthony Kennedy in both cases and the Chief Justice in another start to really take note of race in ways that are a little bit unfamiliar if you look at their sort of corpus of work. So Pena-Rodriguez will go first. This is a case that comes out of Colorado, and the question is essentially pretty simple, and that is, can the courts kind of pierce the veil of privacy around what happens in jury deliberations? And this is a long-standing, it far precedes our Constitution, a long-standing trend in jurisprudence that says we're not going to go back in and micromanage a jury based on things that were said in the jury room. And so 42 states in the federal court have what are called no impeachment rules that bar you from probing what jurors said to one another when deliberating in a case. And this is for obvious reasons. You want free discussion, you want no chilling of what jurors will say, and you want finality. You can't go back and relitigate every jury deliberation. And so there's a sense that you can correct for jury bias at other stages in the trial. You can do it at voir dire, you can do it during the trial, and so we don't mess with what jurors say to one another in the jury room. Now, some states have an exception to this rule where they say if something overtly racially tainted is said by a juror, you can pierce that veil. Colorado is not one of those states. And so here we have a racetrack worker in Colorado, Miguel Pena-Rodriguez, and he's charged with sexual harassment of 2 teenage girls. And he is convicted. He has to serve 2 years probation. He has to register as a sex offender. And after his conviction, 2 of the jurors come forward and say, I have to tell you, there was a guy there in the jury room who was saying some pretty inflammatory things about Mexicans. And it turns out that what the juror was saying during jury deliberations is that, quote, Mexicans take whatever they want, and this is a very, very macho culture in which, quote, Mexicans do whatever they want with women. This juror happened to be a former police officer and so had increased credibility. And he went on to discredit another Mexican witness in the case, describing him, quote, as, quote, an illegal. And so, needless to say, Pena-Rodriguez thinks that this is a racially tainted jury deliberation, but he loses in the lower courts in the Court of Appeals. And in March, before 8 justices, the Supreme Court rules 5-3 that, in fact, we can pierce this jury deliberation, that something so untoward happened in this discussion that we need to have it looked at again. And the opinion is written by Anthony Kennedy. He's joined by Ruth Bader Ginsburg, Sonia Sotomayor, Elena Kagan, and Steve Breyer. And what they say essentially is we're going to have an exception to this no impeachment rule if something so grotesquely racially tainted happens that it violates the Constitution itself. And Justice Kennedy, who again has been very, very inconsistent in how he thinks about race, writes, quote, a constitutional rule that racial bias in the justice system must be addressed is necessary to prevent a systemic loss of confidence in jury verdicts, a confidence that is a central premise of the Sixth Amendment right to trial. And then he dismisses in other cases where the court had said, we're not going to get involved in what jurors said during deliberations. He said that had to do with if they were on drugs, they were drunk, if they came in the tank for someone. That's different. This is a constitutional, almost an unspoken equal protection rule that says that you have been robbed of your right to a Sixth Amendment free trial if there are race-based decisions being made. Samuel Alito writes a dissent joined by Clarence Thomas and the Chief Justice, and says it's admirable that Kennedy and the liberal wing of the court want to fix this problem, but they're creating a rule that is unworkable, and everybody's going to run in now and relitigate their jury deliberations. And Kennedy's careful to cabin his rule. He says there has to be actual racial bias. There has to be, quote, a clear statement of racial bias. It has to be, quote, a significant motivating factor. But it really is, I think, in a deep way, Kennedy recognizing that race still plays a role. And if we want folks to have confidence in jury verdicts, we have to be able to correct for that. The second case is called Buck versus Davis. This comes out of Texas, again, as do so many death penalty cases. Dwayne Buck is charged in 1995. This case has been kicking around for decades for the murders of his girlfriend and another man. Texas is a state that, in order to impose the death penalty, requires the jury to affirmatively find future dangerousness in the defendant. Buck's own attorney dubiously puts up a witness who says, oh yes, based on his race, he is in fact going to have a likelihood of being dangerous because he's African American. This is his witness. He says statistically African Americans are much more likely to pose a danger of future violence, and so Buck is sentenced to death. In this case, we have Chief Justice John Roberts and Anthony Kennedy joining Sotomayor, Breyer, Kagan, and Ginsburg to say this is a bridge too far, to even suggest that this doesn't infect how the jury thinks about it. To have your own witness getting up and saying he's African American and therefore likely to harm someone again is beyond the pale of what we can allow. And there's an interesting line from Chief Justice Roberts, who, don't forget, not so long ago said the only way we can get beyond race in America is to get beyond race. Nevertheless, writing in this case, in his majority opinions, quote, some toxins can be deadly in small doses, and the toxin that is racism can be lethal and determinative in small doses. Clarence Thomas dissents in this case. He says the jury maybe came to their decision to give the death penalty based on the heinousness of the crime. The evidence was overwhelming. It has nothing to do with future dangerousness, and that, you know, the introduction of the idea that black people are more dangerous was of, quote, minimal effect. And so you have the Chief Justice, again, I think, really taking note that even though he wants to live in a colorblind America, he doesn't, and that sometimes the court has to step in.
Erwin or Fred, do you want to add anything about those cases?
A couple of thoughts. One is practically what these cases will mean for lawyers. I think Pena-Rodriguez leaves open many important questions. It says when there's this expression of racism, the trial judge has to hold a hearing. But what happens then when there's the hearing? Also, this is a case about the expression of racism in jury deliberations. What if it's the expression of anti-Semitism or homophobia or sexism? Can the jury verdict be impeached on that basis? With regard to the latter case, Buck versus Davis, does this reflect the court's going to be more sensitive to claims with regard to ineffective assistance of counsel? I can count on less than the fingers of one hand the instances in which the Roberts Court has found ineffective assistance of counsel. Is this going to suggest that the Supreme Court and maybe the lower courts are more amenable? The other thought is in terms of the larger significance of the case and whether this shows a court that's going to be more sensitive to the problem of racism in the criminal justice system. It's interesting that Chief Justice Roberts writes the latter case that Dahlia talked about, Buck versus Davis, and speaks so eloquently about how some toxins are lethal in even small doses. But he's in the dissent in the first case you talked about and didn't seem so concerned about racism there. Studies show that racism affects every aspect of the criminal justice system, from who the police stop and who they arrest, to the charging decisions made by prosecutors, to what juries do, to the death penalties imposed. I'd like to believe that these two cases suggest a court much more sensitive to the problem of racism in the criminal justice system. But again, they might be much more limited to just these two factual situations.
So Fred, I want to turn to some of the foundations of our democracy, and that's about elections, a small topic.
Here's the topic.
You're right. But let's talk a little bit about gerrymandering. So this was a case this year, Cooper versus Harris, about redistricting. So what happened in that case?
Well, in Cooper versus Harris, the court puts its toe in the dangerous waters of gerrymandering, and we'll come back to that next term in a more provocative context I'll come to in a moment. But Cooper involved the North Carolina redistricting after the 2010 census. The state legislature, in order to, it said, comply with the Voting Rights Act, sensitive to black majority districts, regrouped voting blocks, regrouped districts. These were districts, incidentally, that had African American representatives from them without having additional African Americans in those districts. So the redistricting that took place after 2010 pretty patently involved a rationale of racially grouping larger groups of African Americans, which had the obvious effect of not having those populations in other districts, therefore freeing up a larger white population of those districts, relatively speaking. And I pause there because there's obviously a political current of this as well, that those districts are therefore more likely to go Republican than Democratic. This was challenged in the court, a 5-3 decision written by Justice Kagan, joined by Justices Ginsburg, Breyer, Sotomayor, and one other I'll come to in a second because that's the kicker. There's an opinion concurring in the judgment, dissenting in part by Justice Alito. That's joined by the Chief Justice and Justice Kennedy. Justice Gorsuch was not on the court yet, so those of you counting justices notice that the missing vote in the majority is none other than Clarence Thomas. And that did have the predicted effect out there. Very good. The court found that race was the predominant rationale for the redistricting, and that, according to the doctrine, then shifts the burden over to the state to show that it had a compelling interest to sort the voters based on race, and that it did so in a narrowly tailored way. The state raised the argument of the Voting Rights Act and said that its compelling interest here was to comply with the Voting Rights Act. The majority, in the opinion by Justice Kagan, said that this was not necessary to comply with the Voting Rights Act. And as I said earlier, the votes were not necessary to be moved in that direction in order to achieve any particular result with respect to race. And therefore, the court found that this was not justified and was, in fact, a violation, racial discrimination with respect to gerrymandering. Now, Justice Thomas joins in one of his opinions in which he speaks ringingly of the need for racial blindness in this area. And in fact, it's one of the great titles. This is actually not Dahlia from Slate. It's one of your colleagues, Mark Joseph Stern, who writes the wonderful article with the title, "Clarence Thomas Joins Liberals, Shocks World." I think having written the headline, he had to write the rest of the article to go with it. He goes on to say, in a welcome change, the decision did not split along familiar ideological lines. Justice Clarence Thomas joined the 4 liberal justices to create a majority following his race-blind principles of equal protection to an unusually progressive result. The concurring part dissenting opinion of Justice Alito, joined by the Chief Justice and Justice Kennedy, argues that the plaintiffs actually had a higher burden. It wasn't enough just to show that race had been the compelling, did not meet a compelling interest here, and that race was the predominant factor. They actually had to show that there was a different way of doing what the state legislature did. The majority opinion says that's putting too high a burden on the plaintiffs here. Having shown that race was the predominant factor, that shifts the burden to the state, which the state could not make in this case. We'll talk at the end of the program a little bit about cases coming, but I'll just mention now that in many ways, Cooper against Harris is the appetizer. The main course is yet to come. That's Gill against Whitford, the Wisconsin gerrymandering case. That's not racial gerrymandering. That's good old-fashioned political gerrymandering. The court has stayed out of that for some time. Partially Justice Kennedy, who was sort of the missing vote to make a majority for striking down political gerrymandering, said if I could see a test that was articulable, I might be interested. Well, he will be on the court next year, having not retired a week or two ago, And we'll see when the Wisconsin case comes up whether he finds a test that is articulable enough for him to join what would then be a majority to strike down political gerrymandering.
Erwin, did you want to add something?
I want to disagree just a little bit. I certainly agree with Fred's wonderful description, but I think this case is more than an appetizer. I think this is a case that's going to have real significance, particularly in southern states. Let me try to explain by putting it in some historical context. In the early 1990s, the Supreme Court said, if the government uses race as the predominant factor in drawing election districts, even to benefit minorities, it has to meet what's called strict scrutiny. Its action has to be shown to be necessary to achieve a compelling purpose. These were cases that arose in the context of legislatures trying to use race in drawing election districts to make it easier to elect minority representatives, easier to elect African Americans and Latinos. And these were 5-4 decisions, with the conservatives saying you can't use race in drawing election districts, and the liberals wanting to allow it to benefit minorities. Then in 2001, the court decided a case called Easley versus Cromartie, and the court said, if the government is using race as a proxy for political parties, then it's permissible. And this was a case out of North Carolina, like the one this year. In North Carolina, African Americans vote overwhelmingly Democratic. And Justice Breyer, writing for the court, said, if the legislature is looking at race as a proxy for party, then it's okay. And that was 5-4 with the liberal justices in the majority. But this created an almost metaphysical question when it came to districting. Is it race or is it party, knowing that they're so intertwined it can never be separated? The context changes when you get to this decade. Now the cases arise in the context of Republican-controlled state legislatures, especially in the South, wanting to use race for partisan gerrymandering purposes. That's what went on in North Carolina. The Republican-controlled legislature wanted to use race so as to put African Americans in fewer districts to maximize the election of seats for Republicans. And they said, we're using race for party purposes, so it's okay under Easley versus Cromartie. I think the significance of this case is in Justice Kagan's opinion saying it doesn't matter if it's race or it's party. When race is the predominant factor, the government has to meet strict scrutiny. And I think that's why Justice Thomas joins together with Kagan and Ginsburg and Breyer and Sotomayor. And I think this is going to make it easier to challenge the partisan gerrymandering that's gone on, especially in southern states, where Republican legislatures are trying to preserve, say, seats for them. I agree with you that the court's going to take on the larger question of partisan gerrymandering, but I think this case has real significance in itself.
So, Erwin, I wanted to stay with you for one more minute,
Sure.
And that is about a case that we were expecting was going to be a big case from this term, and the ADL had actually already filed a brief with the U.S. Supreme Court, and then the court remanded it to the lower courts. And that is the Gavin Grimm case, which is about transgender bathroom use. Can you talk a little bit about what happened and why the Supreme Court never actually heard oral arguments in that
Sure.
case?
The case as it came to the court was called Gloucester County Board of Education versus GG. And it involves a person who was born biologically female, before high school said that it had a male identity, before sophomore year of high school changed first names and changed the pronouns used. Parents and the student asked that the boy be able to use the boys' restroom and the boys' locker room. The school said no, that the boy could use a restroom in the nurse's office. The parents felt that that was stigmatizing. The Department of Education in January 2015 sent out a letter to schools across the country saying it interpreted an important federal civil rights statute as protecting transgender students. Title IX is a civil rights law that says that schools that receive federal funds can't discriminate on the basis of sex. The Office of Civil Rights, Department of Education said, we believe that discriminating against transgender students is discriminating on the basis of sex. And on May 13th of 2016, the Office of Civil Rights, Department of Education, the Civil Rights Division of the Justice Department sent out another Dear Colleagues letter saying that they interpreted Title IX as prohibiting discrimination against transgender students. The boy's parents and boy filed a lawsuit in the federal district court. A year ago spring, the United States Court of Appeals for the Fourth Circuit ruled in favor of the boy and his parents, saying that to deny the boy the ability to use the boy's restroom violated federal law, Title IX. The Supreme Court granted review. The focus of the case was really about a technical legal issue. how much deference should be given to the agency when it's interpreting its own regulations in the statute. The case was fully briefed, it was ready for argument, but then the Trump administration said it was rescinding those 2 dear colleague letters, and the Supreme Court, in light of that, then dismissed the case as improvidently granted, sent it back to the lower court. But even without these dear colleague letters, the issue of rights for transgender students is going to remain in the courts. The students on their own are going to litigate this under Title IX. The students are going to litigate it under equal protection. And so it's an issue that's sure to come back to the Supreme Court, but in a different legal context.
Thank you for that. So, Dahlia, I wanted to turn to another issue because, as we've heard, the headlines this year have not been so much about the cases that the Supreme Court actually heard and decided, but the biggest headline was about the Muslim ban, the travel ban, the refugee ban, whatever the term is that people use most often. But so what is happening with that executive order, and what do you think we can expect next year from this case?
I was about to say I couldn't believe we'd made it through 54 minutes of the program and nobody said Donald Trump. But then Erwin went and stepped on my joke. So as you all know, in the first week in office, Trump issued an executive order related to immigration and travel to the United States. This was meant to be putting into effect a promise he had made during the campaign to create, at the time, what he was calling a Muslim ban. And as you all probably remember, any lawyer with a laptop made their way to an airport, and quickly, the ban was challenged. The initial executive order, the first iteration, barred admission of nationals from 7 majority Muslim countries: Iraq, Iran, Somalia, Sudan, Libya, Syria, and Yemen. It included legal permanent residents and green card holders, or it did for a few hours and then it didn't, depending on who you asked. It was incredibly hastily cobbled together, and it suspended the refugee program for 120 days, indefinitely suspended refugees coming in from Syria. Within a day of the travel ban, the original travel ban being enacted, judges were hearing litigation all around the country, in Virginia, in New York, in Washington State. And as you probably recall, a judge in Washington State enjoined the original executive order. And then on February 9th, a 3-judge panel of the Ninth Circuit Court of Appeal upheld that injunction, permanently enjoined it. And instead of litigating that, the second executive order was born. And so the administration dropped that appeal. And on March 6th, they issued a second, narrower executive order that was narrowed to now 6 majority Muslim countries and supported by documentation from DHS and from the Justice Department saying, no, there's really a basis for this. Let us tell you about the connection between Muslim terrorism and these countries and why we had to pick these countries. It was again immediately challenged. Courts in Hawaii and Maryland enjoined it again. And again, it goes up now to the 4th Circuit Court of Appeals based in Virginia and to the 9th Circuit Court of Appeals, where these cases are argued again with this really fascinating Jeffrey Wall, who represents, who's the acting Solicitor General, the valence, the posture for the case. And imagine, if you will, the 4th Circuit hears this case en banc. So you have 13 judges, and the word Twitter has never been deployed as often in an oral argument. I mean, they're literally trying, to grapple with Trump tweets and campaign statements. And Jeffrey Wall, who's the acting Solicitor General, his litigation posture in both the 9th and the 4th Circuits is, we have a presumption of regularity, is the language he uses, that Donald Trump is the president. He did this in conjunction with his duly appointed Attorney General, his Homeland Security Chief. Whatever he said before he became president is immaterial. The tweets are immaterial. What matters is this is the president, and we accord him vast and expansive policymaking powers in the immigration and national security context. Both the Ninth Circuit and the Fourth Circuit rule against the second executive order. The Fourth Circuit is a much broader ruling. The Ninth Circuit ruling is narrower. But both really say this still evinces anti-Muslim animus. It has not been cleansed of the original animus. And more pointedly, in the Ninth Circuit, very pointedly saying there's just no connection between these 6 countries that are being banned and this action that is being taken and what was done in this executive order. That was appealed in June directly to the US Supreme Court. The Trump administration sought to have the entire injunction lifted, and on the last day of the term, dear God, was that Monday? A week Monday. Feels like 100 years ago. The Supreme Court waded into this issue. They partially lifted the injunction. They agreed to hear this case. In October, they said that the time starts now for this extreme vetting. We're setting the clock now. They explicitly asked the parties to brief the question of whether by starting the clock now on this vetting period, this issue might be moot when the court hears it in October. So as Fred said about Trinity Lutheran, this could either be a big, big deal or it could be a little deal. It could entirely be the case that by October, everything that needed vetting was vetted and the clock has run. I think that the operative words in the order that the court, it's a per curiam order, so it's unsigned, which means we don't know who wrote it. But in that order, the operative words are that people will be allowed to get around the travel ban if they have a credible claim of a bona fide relationship with an American citizen. Now, what that means is probably going to be determined both by guidance that the Trump administration has now offered up. Grandmothers are in, mother-in-laws are out. No, grandmothers are out,
Right.
mothers-in-law are in.
Mother-in-laws better be in. That's
Yeah, no. It's clearly like a Jewish justice. Mother-in-laws are in. But I think that it is incredibly vague in terms of what this bona fide relationship is going to look like. Already, we have refugee groups who are trying to figure out which refugees are eligible under this test. But I think the important sort of going forward until October is going to be just a raft of trying to clarify what that relationship means. I think I'll just end by saying this looks like a pretty deft compromise by Justice Kennedy and the Chief Justice. Again, it's an unsigned order, but it gives both sides a little bit of something, gives neither side a big win. You know it's a deft compromise when both sides claim that they had an extraordinary win in this case. So the Trump administration felt that this was a decision on the merits and the travel ban is constitutional. Opponents say we're going to see in practice this probably does less than anyone thinks it does, and it's time limited. So by the time October rolls around, maybe this whole thing vaporizes. It's worth flagging that the dissenters in this case, not surprisingly, Clarence Thomas, Samuel Alito, and Neil Gorsuch, who would have lifted the entire injunction and allowed the ban to go into effect. And in language that's very telling by Clarence Thomas, when he signs his concurrence saying, you know, I would have gone further, he says the plaintiffs, Trump would have won on the merits in the lower court. So he is signaling, in his view, Trump would have won this regardless. And the order, while it gives examples of who might have a bona fide relationship, if you're a visiting lecturer who wants to speak to a university, if you're the mother-in-law of the plaintiff in Hawaii who can't come visit her grandchildren, you're in, arguing by example doesn't clarify categories. And so really going forward, I think there is a massive question. All we really know is that the court has agreed to hear this by October, and the court will include Anthony Kennedy, who I think very much wanted to be on this case.
Did either of you have a different take? Or
You know, this has
something
been
to add?
such a year of, you know, what I'll call, not the least bit facetiously, constitutional anxiety for constitutional lawyers, constitutional scholars, for citizens who care about the Constitution. But I want to look for a glimmer of light in this moment. And that is, I bet I'm not the only one in this room or listening today who had the experience of listening live to the oral argument in the Ninth Circuit. It was a major educative moment for the general population to listen to an oral argument. I mean, for some of us, every word of it is riveting. I imagine for some people, just how much collateral estoppel can you take? But for some of us, it just doesn't get any better than that. But I do think seriously that there's a level of engagement on constitutional issues that is heightened. For good or for bad reasons, but that's where we are, and this kind of seriousness of engagement for it. So I think that's a glimmer of light. Other than that, I certainly will watch with my constitutional anxiety this October in the argument, because I think Dahlia's right. It's a masterful compromise in some ways, but in other ways there is so much vagueness and play in the joints here that when one finds oneself sort of hoping for mootness as the way out, it tells you the corners that we're getting ourselves into.
I agree with Dahlia that I think what the court did in its order is reach a compromise, but I think it's a compromise that makes little sense either as a matter of law or in terms of human lives. With regard to the law, when a court goes about deciding whether to lift an injunction, the key issue is whether or not the party that's asking for the injunction lifted has a substantial likelihood of prevailing on the merits. Does the United States government have a substantial likelihood of winning in the Supreme Court? Yet the justices don't address that question, and that question should not in any way turn on whether somebody has a relationship to the United States or not. If the Fourth Circuit is right that this is motivated by religious animus, then the entire executive order is unconstitutional, both for those who have and those who don't have a relationship with the United States. If the Ninth Circuit is right that the order violates federal law because discrimination based on nationality, then the entire order is invalid, both for those in the United States and those outside, without a relationship to the United States. And so as a matter of law, I don't see how the compromise makes sense. But in terms of human lives, I'm even more troubled by this. The idea that people can't come if they have a fiancé in the United States, because the guidance that was issued last Wednesday by the Trump administration says fiancés aren't included, that people can't be with their grandparents who are outside the United States. I've also heard in universities that just since a week ago Monday, the Trump administration is being much more aggressive in denying visas to students, to faculty, even though they would fit within the court's definition. What the Supreme Court has done is empowered the Trump administration to try to be as restrictive as it can. And of course, this is now all being litigated in the courts, and I think it will be. And so I think the court would be much better off leaving the injunction in place. And here I have to agree with what Clarence Thomas said. Now, he wanted to lift the whole injunction, but he said the court here is inviting arbitrary line drawing, and that's what we're already seeing.
And if I could just add a coda to Fred's glimmer of light, I want to add a really depressed coda. Because I just don't think we can talk about this litigation without talking about the fact that Donald Trump has referred to judges in this litigation as so-called judges, and referred to a federal district judge in Hawaii as a judge on an island in the Pacific. I mean, I think that it's really one of the important valences around this case really is, even though we don't say it out loud, how much we can destabilize the judicial branch, how much the executive branch can destabilize the judicial branch, and how does the judicial branch respond to that. And I think one of the real sort of undergirding themes of this litigation is that judges who have had to have their security doubled in some instances, who have genuine threats to their lives because of decisions they've made, don't get to answer back. And so one of the ways that this case is playing out is that judges who don't have, because of their judicial canons or the decorousness of the judicial branch, doesn't have the option to say, I'm not a so-called judge, you're a so-called president. They say nothing, and it's in their heads that this is profoundly undermining rule of law and profoundly undermining the independence of the judiciary. but they don't get to write it. And then I think you get this slight disconnect between the opinions that are being written, the Fourth Circuit opinion that is such a blatant charge of animus. And I don't think it's only about racial animus. I think it is the only way judges know how to speak back in a sort of constitutional system that prevents them from doing that.
I think our two glimmers are actually connected. I think one of the reasons you do see the public, or a group of the public, focused on listening to an oral argument. I mean, if this weren't so serious, it would almost be comical. That people, are willing to do that is that the court has a kind of heightened sense of legitimacy when so much else comes unstuck. And we have examples in our time of other Western democracies where when the executive branch or the legislative branch becomes questioned in terms of its competence, in terms of its honesty or integrity, that the court's integrity and the court as an institution and the court's legitimacy in these other countries have actually been heightened in a certain way. So I think that bears watching as well.
Well, I wanted to add one more glimmer just as an attorney, that after watching all these attorneys filing things at the airports, people suddenly thought that we were superheroes. So that was a nice little perk. So Fred, I wanted to talk about another executive order that has gotten less attention, but it's one that we have been filing around the country in cases challenging it, and that is the executive order defunding so-called sanctuary cities.
Yeah, 5 days after taking office, the president signed an executive order to block federal funding to sanctuary cities, jurisdictions that refuse to help the federal government apprehend and deport undocumented persons. There are three different issues or three different laws here involved, and I'll go through them rather quickly in light of the time. One is that executive order. The second is a Texas law that was just passed. And then the third, fresh as of last week, is a bill just passed by the House of Representatives that now has made its way over to the Senate. The executive, that was in that direction. Well done. The executive order was challenged in court by the counties of San Francisco and Santa Clara, and in an opinion by Judge Orrick was enjoined for a number of different reasons, and just going through them relatively quickly. One is a separation of powers argument, that the president cannot cut off funding, that takes Congress to cut off funding. A second, a federalism argument that, in fact, states or localities cannot be coerced by the federal government in this way, that if there are going to be funds that are conditioned, it has to be done ex ante, not ex post, and there has to be a nexus between the granting and the funds and the actual interest involved. Here, there's an interest, if any, in attacking sanctuary cities, but the penalty from the government will be reducing all federal funds, so that there's a mismatch in the nexus, Judge Orrick said. There's a commandeering question here in terms of local law enforcement being commandeered and used for enforcement of federal law enforcement function. And finally, a vagueness set of questions in terms of what exactly do we mean by a sanctuary city. It was not particularly well defined in the executive order, and so there's a vagueness issue as well. After the Attorney General issued a statement that addressed some of this, Judge Orrick has, or at least it has been reported that Judge Orrick is reconsidering the opinion. That injunction remains in place with respect to that order, and that's a district judge opinion on that executive order. The Texas statute, which is sort of an interesting variation on the theme, is a state statute against sanctuary cities within Texas that has been challenged in federal court on grounds of human rights, on grounds of illegally diverting police resources in localities to fighting local crime to enforce U.S. immigration law. So even though this is a state law, not an executive order, it has some of the same kinds of issues we saw with the executive order. And just a week and a half ago, I can't remember a time in this panel that we've done, Erwin, for how many years, where we're actually talking about things in real time, things that have happened within the last week. And I don't mean the decisions decided on the last day of the court, that we always do, but things that are still in the process of happening. So just about a week and a half ago, the Trump administration filed a brief in favor of the Texas law in Texas court. Not so surprisingly, that litigation will go on. And most recently, just last week, on the same day that the House passed Kate's law, the bill dealing with some of the issues of punishment of refugees or of illegal immigrants. But in addition, there is the bill on sanctuary cities that's involved. So now it's a bill. Now it's legislation in Congress. So that would certainly deal with the separation of powers issue. But it still leaves the federalism issues, whereas the nexus, it's a slightly tighter nexus in this bill if it makes it into law with respect to law enforcement funding. But is that what the bill winds up being? Does it even get passed by the Senate? We'll find out. Advance notice is still an issue because some of these would affect funds, and therefore the sanction would be ex post, ex ante as it has to be. There are still commandeering questions. There are still vagueness questions. So if, in fact, this legislation is passed by the Senate, and if, in fact, there is legislation then that goes to the president and he signs it, I suspect that we'll be talking next year about the litigation that came out of that law as well. The only issue that's different from this in the executive order flat out is the separation of powers issue, because now it's not an executive order, now it would be legislation.
So Erwin, we've talked a little bit or alluded a little bit to what we can expect next year, but can you give us more of a general sense of what's coming up and what we might be talking about on this stage this time next year?
I get to do the coming attractions and why you should come back and why you should watch next year. We've already alluded to a couple of those cases. Dahlia talked about the travel ban cases that are going to be argued in October. Fred mentioned a case, Gill versus Whitford, that involves whether federal courts can review challenges to partisan gerrymandering and when it violates the Constitution. As you know, partisan gerrymandering is where the political party that controls the legislature draws election districts to maximize, say, seats for that party. Partisan gerrymandering is nothing new, but because of computer programs, it's become so much more sophisticated and effective. It's possible for a political party to get a little bit more than half of the votes for the seats and then draw the election districts to give themselves 80% of the seats in the future. And that's, for example, what's exactly happened in North Carolina. North Carolina is a fairly purple state. It went for Barack Obama in 2008, Mitt Romney in 2012. It went for Donald Trump in 2016. The Republicans got slightly more than half the votes cast for the state legislature, then drew election districts to give themselves supermajority control of both houses of the legislature. In two cases, in 2004 and in 2006, the Supreme Court 5-4 said the challenge to such partisan gerrymandering are not justiciable in the courts. They're political questions that the courts can't decide. Justice Scalia wrote and said, we just don't have any standards for deciding when partisan gerrymandering goes too far. Justice Kennedy wrote a separate concurring opinion and said, well, we don't have standards today. When we get them in the future, we shouldn't completely close the door. A 3-judge federal court in Wisconsin in November said, we've got a standard. We'll call it the efficiency gap. If the percentage of votes for the legislature is very different than the number of seats that party gets, and it goes too far, it's unconstitutional. The Supreme Court granted review. I think this is enormously important for our political system. A couple of years ago, Justice Ginsburg said, we were all taught that voters are supposed to choose their elected officials. We now live in a world in most states where elected officials choose their voters. So it'll be interesting to see what the court does. Another really important case the court granted review in a week ago Monday is the Masterpiece Cake Shop versus Colorado Civil Rights Commission. This involved a baker who refused to bake a cake for a gay wedding. Colorado has a law that prohibits businesses from discriminating on the basis of, among other things, sexual orientation. The bake shop says, you've infringed our free exercise of religion, you violated our free speech by refusing to allow us to do this. One interesting thing about the case is it came to the Supreme Court decision of whether to grant in December, and time after time, I think about 16 times, the case was relisted. I thought the couple was going to be divorced before the Supreme Court decided whether to take the case. But they did take the case, and the underlying issue is enormously important. To what extent can people discriminate on the basis of their religious beliefs? Can a business discriminate on the basis of religious beliefs against gays and lesbians? And if so, then can a business say, it's based on my religion, I can discriminate against an interracial couple, or against blacks because that's my religious beliefs, or against Jews because that's my religious beliefs? And so the underlying issue here is, when can people discriminate against others on account of their religious beliefs? One other case I'll mention for next term is a case called Carpenter versus United States. If the police want to locate where somebody is based on cell tower records, do they need to get a warrant for that? Our cell phones are constantly giving information about where we're located. Will the police need to be able to get a warrant to do that? Or the police can just go and get that information? So these are just a few things, but I think it certainly shows it's worth coming back next year.
Yes, please do. And I think we're going to have a busy year, it looks like, at ADL. We're already talking about a number of these cases and which ones we're going to be filing in, as I know are a number of other civil rights organizations around the country. So we have a few questions from the audience now. We only have a few minutes left. So the first one is, if a religious entity receives federal funding, can they be held to anti-discrimination standards?
I mean, in some ways, you know, that's a cousin of the Baker case.
Right.
I mean, I think in terms of to what extent, you know, is a religious institution allowed to use religious grounds for discriminating? I'm not sure the federal funding there changes that part of the equation.
Right, well, let me answer it a slightly different way. I agree with Fred. The Constitution applies only to government and government institutions. So if a private corporation or private university wants to discriminate or fire somebody for speech, the Constitution doesn't apply. But of course, there are federal statutes and state and local laws that can say that private entities can't discriminate, or even that private entities can't fire people because of speech. The fact that a private entity receives money from the government is not enough to make the Constitution apply. So what Masterpiece Cake Shop is about is a Colorado civil rights statute that says that businesses can't discriminate, among other things, based on sexual orientation. And then the cake shop that wants to discriminate says, but if you apply this law to us, this infringes our free exercise of religion. This violates our free speech.
So a different question, Fred, this is an issue that you raised in terms of talking about the Muslim ban. And it says many viewers tuned into the Ninth Circuit hearing in that case. How important do you think it is to have cameras in the Supreme Court? Maybe this is a question for you, Dahlia, actually. And will that happen? Question for anybody.
First of all, stop and think about the fact that we all watched the Ninth Circuit and it was a black screen. I mean, we didn't watch the judges. It was extraordinary that people pulled up on YouTube the audio of that argument and were riveted by it. And you know, I think it's tremendously important. I feel like I say this every year. I think it's a sin, you know, that one of our three branches of government has a handful of seats, and that people stand in line, you know, including parties in Obergefell, standing in line hoping to get in. So I think cameras are vital. I do think this is an interesting moment where, you know, the White House is now doing some version of what the court is doing, and really, really controlling who gets to cover White House press briefings and how and what we're going to do with the audio. And you know, I just wrote a piece last week saying, "Oh, stop complaining, White House correspondents. We've been blacked out for years." But I think it's critically important, and I do think that it goes to this underlying question we've all talked about: this anxiety about the independence of the courts and the institution of the courts. And I think that the folks who tuned in and watched the Fourth Circuit, watched the Ninth Circuit, came away saying, this is not partisan politics. This transcends who appointed you. This is really profoundly different from straight politics. And what better message? I think this goes to Fred's point. If people want to see that and courts continue to behave decorously and thoughtfully, why would we be blocking them out of watching, I think, the last institution in this country governed by norms of good faith and fact? Why are we telling people they can't watch that? As to when it's going to change at the Supreme Court, never.
The only caveat on that, if I had to bet my own money, I'd bet with Dahlia on this that they don't. But the one caveat on that is that it is a different reason now. It is a way in which a Chief Justice who deeply believes in the institution of the court and the legitimacy of the court might just say that this is the time for us to stand up in a different way. I don't know that that will happen. It would be a dramatic gesture, and it would be a remarkable educative moment for the public. I mean, I can remember the day that the Bakke decision came down. Now, this is obviously before you could go online and get the opinion to read right away. National Public Radio read it out loud. And there were people in not just law offices, campuses, and office water coolers all over the country who listened to the Bakke decision being read out loud. So now you can get it online, and you could watch an oral argument live. I think the court could jump in a very interesting and powerful way for the institution of democracy.
So we have another question, and that is, the day after the Trinity Lutheran case, the court vacated and remanded a Colorado voucher case. What does Trinity Lutheran mean for vouchers?
In 2002, in the Zellman case, the Supreme Court upheld 5-4 an Ohio system that provided vouchers for children in the Cleveland area. The vouchers could be used for any private school, secular, religious. Turns out that 96% of all the vouchers were used in religious schools. But Chief Justice Rehnquist, writing for the majority, and Justice O'Connor, writing a key concurring opinion, said that this is a narrow case. And of course, it was about the government choosing to allow the vouchers to be used in parochial schools. Now, of course, what you're going to see is challenges arguing that if the government doesn't allow vouchers to be used in religious schools, that violates free exercise in the same way of not allowing the religious schools to get aid for the playgrounds violated free exercise. And I think it'll be interesting to see the Colorado case in remand and so many others as these challenges get brought, where religious institutions argue that denying them aid violates their constitutional rights.
I mean, this was the footnote in Trinity Lutheran. And the question is, was that just to buy peace for this term, and do things change now? I think that's bears watching, and I think in all likelihood we'll see that relitigated in the lower courts and rediscussed, if not the next term, then the term following.
Dahlia, did you have?
No, just that I think that when you read Sotomayor in Trinity Lutheran, she sees the sky falling. And it's very hard, I guess Fred said this, to reconcile, her scope of panic. She's saying if you are going to give playground resurfacing, you're going to give pews and stained glass. And the majority, I think, says, no, we've cabined it. Look at the footnote. And I think literally we don't know. And so that we're in a very weird world where we're in the interstices of the claims of, what order of magnitude the sea change has been, and we literally don't know. I think what we can say is Gorsuch is a strong vote, for tearing down that wall.
So we have one more technical question, and that is on the refugee ban. So if people who are barred have no bona fide connection to the U.S., will there be a problem of standing if they try to bring a case?
Well, in part, the Ninth Circuit case was a great victory for educational institutions in terms of standing of educational institutions on behalf of who we could bring to campus and who, as students, as faculty, as postdoctoral fellows. So, I mean, standing will continue to exist in those contexts.
I think those who are denied admission suffer an injury. That would be sufficient for standing. And so they'll be able to litigate whether they have a bona fide or don't have a bona fide relationship. But if they truly have no relationship, I think they've got an injury, but they're not going to win under the Supreme Court's order from last week.
And it's probably worth pointing out that the order, the per curiam order, was at pains to say, who doesn't have a bona fide relationship? Refugee organizations that reach out to people and then try to confer, a bona fide relationship on someone in a foreign country. So it's interesting that they were very clear don't try to find standing by, finding your way to a group. And I thought that was a really interesting marker going forward.
Yeah.
So it is very clear that if this term was one of a lot of consensus and few cases and not as many headlines as we have seen, next term I think will be very different. We have heard about a lot of cases that are coming up that I think are going to be blockbuster cases, blowout cases. And so we hope that all of you will join us again this time next year for the Supreme Court Review. That will be the 19th annual Supreme Court Review. Thank you all for tuning in. Thank you to our audience here. And thank you to our amazing panelists.
We started this when we were in college. I want everyone to know. They began inviting us. I was going to say high school, but that doesn't sound credible. Magnificent.
This was so wonderful.
I'll believe it if you'll believe it.
That's exactly right.